Kunaarifiwa kwamba kwa hivi sasa turejee mahakamani ambako mbunge wa Juja George Koimbori amefikishwa katika mahakama mjini Kiambu kutokana na tuhuma ambazo zilikuwa zinamkabili za kutumia mitandao ya internet kwa njia ambayo haifai. Hebu tusikilize.
Contained in the initial file. I leave it to Mr. Jomo and Mr. Manza to proceed and my colleagues.
The observation that I had made before as regards count number 7 that has been framed by the DPP is on the difficulties that are being advanced prejudicial to the accused person to respond to that particular charge. Because if you look at the particulars of that offense, is that it is referring to a matter 7/15 of 2021. Njomo. So that what is the fate of the accused person in saying, responding yes or no, even keeping quiet, as regards that particular count? That is the inability that faces the accused person at this moment, because he doesn't know the particulars to which that offense relates. The only fair procedure, because the accused person is entitled to a fair procedure and a fair hearing, is that those issues of 7/15 of 2021 must be dealt with within that particular laws, so that he can come and tell you that the reason why I did not attend court, assuming that the matter was withdrawn because of failure to attend court, was because of 1, 2, 3 reasons, and it happens all the time. We don't know, as we stand here, or he doesn't know, whether there were warrants in place that he can respond to say whether it is true or not true. He does not know whether he had been served with any warrant, if any had been issued, so that he can again say it is true or it is not true. In summary, Your Honor, it is not possible for the accused person at this juncture in time to respond to any allegations in 7/15 of 2021 without having the benefit of the record of that particular file, so that as he can respond to all the other offenses, this particular count number 7 will be a difficult position for him that he cannot respond to. In all fairness, Your Honor, bringing this particular count at this point in time without any information at all will be highly prejudicial and will flout the rules of fair procedure and his constitutional right to a fair hearing. We oppose to that particular count and charge being pleaded to.
Your Honor, with your kind permission, my name is Daniel Manzo. Your Honor, a matter reinstated under 87A of the CPC means that it had already been pleaded to and the plea responded to. And in this matter, it was a plea of not guilty. So, Your Honor, in the event that matter is reinstated, then it proceeds from where it was left and from the record of the court as of the time it was withdrawn. So if it's a particular file and it's a particular matter, Your Honor, what needs to be done is to bring the person back to court and then proceed with the hearing of that particular matter. I'm aware the prosecution is allowed to amend charges anytime, but that should that happen, then, Your Honor, then there should be a totally new charge. It's a totally different file now if you are to bring up matters. Although you can amend, Your Honor, under the law, it doesn't mean you have to plead again. We have to know what is the status. And for purposes of Article 50, Your Honor, then the accused person has to be accorded an opportunity to explain themselves as to any times he may have missed case or the court case, and also to ascertain whether the days the accused person was not present, whether the matter had already been withdrawn or had been negotiated for withdrawal, Your Honor. We therefore plead with you, Your Honor, that we proceed with the original case, and should there be a need to amend charges or add charges, then there be a proper notification to an accused person so that before they plead, they have already been notified of their charges.
Allow me to summarize by referring you again to section 87 and the last part of it. It says, if it is made before the accused person is called upon to make his defense, he shall be discharged. Now that's where we begin, a comma. But discharge of an accused person shall not operate as a bar to subsequent proceedings against him on count of the same facts. What is before you does not square out with the requirement of section 87, paragraph A. What is required is that he shall be prosecuted, subsequent proceedings against him on account of the same facts. Does the charge sheet before you, is it a new charge sheet, or does it present the qualifications and the principles and the tenets elucidated by section 87A? Number two, and the final one, is this an amended charge sheet? So that then we understand that the DPP has exercised that right. We are most obliged.
Thank you, I wish to submit that the belief that the objection has no basis. The previous case against the accused person, that is file number 715 of 2021, was withdrawn under section 87A. Your Honor, the same section of the gives the DPP power to reinstate the case and does not limit the DPP to conduct further investigation and even bring new charges based on the same facts. I must submit that the charge they are contesting to is a charge that has been brought which is within the facts that the accused person was charged in count 1 to 6. Nothing in law stops the DPP from amending a charge sheet. And in this case, we are not amending a charge sheet. This is a fresh charge. And that is why the case has been given a new number. It is number E343 of 2024. So once a matter has been withdrawn, the previous number ceases to exist. And we have brought accused person with same charges, and further investigations were done, and additional charge was added. So, Your Honor, it is not prejudicial for the accused person to take plea and answer to the new charge. He will have time to respond. We are going to serve him with the statements of the witnesses. He's well represented by a team of advocates who are even senior than me. I can see Mr. Manzo here, my good friend. They'll represent him and be able to respond to the charges. So I don't see that anything that stops this court from taking plea. It's our submission that the court allows the plea to be taken to enable the accused person answer to the charges. That would be all. Okay.
Yes, you know, we highly appreciate the case study of the court. Yesterday, Your Honor, when our client was arrested by the DCI, when we appeared before and we're making an application for bail, we are laying the basis for it. You know, when our client was arrested yesterday, he was presented before the DCI, Serious Crime Unit. The offense that we signed the precautionary court statement to was about cybercrime. A moment, I'm laying the basis for my application.
I don't know that one, Your Honor. Please handle the case before the court.
Okay,
Yeah.
then what I say, let me just take a few minutes and do the ruling and then we can move forward.
Yeah.
That would be fair, Your Honor. Yeah, that would be fair, because you would have laid the basis how the DPP is abusing his powers and representing other interests other than the case.
So my ruling is basically touch on the facts.
Yes, specifically count number 7. Yeah, we are most obliged. We are most obliged.
In 30 minutes?
We are most obliged.
Once she's done with it.
We are most obliged, Your Honor. I agree with your thinking. I agree. I agree. You're thinking I agree.
The same court.
Wakili, uko salama?
Tunapanga pamoja tuli kingine.
Unajua sisi hatuna shida. Hii ni kazi. The only